We're live for a special off-schedule edition of our weekly live stream without our fearless live streaming leader Chuck, who is under the weather this week. Although I have just been texting with him, and Chuck may or may not be watching what we're up to. But we apologize for not being available on our new day on Wednesday. It's already been kind of dicey since our move. I was not on the first one, and I think we sort of have to get our schedules adjusted to the new day. But Chuck is professor, and his teaching schedule changed, I guess. So we have had to change the days for our weekly live stream. We also haven't advertised this. This is going to be a shorter edition, but we promised people we would give an update on our cases this week. And so hopefully people will watch the recording. But I did want to just introduce folks for those who don't watch us regularly. We have Aaron Hall from Joseph and Hall in Denver, and Jesse Bless from Bless Litigation in Boston. Is that the official name of
Yeah.
Okay.
I can go by many names. That's fine.
I'm Greg Siskin in Memphis, and we are 3 of the 4 law firm leaders for Impact Litigation's member firms. We file lawsuits. That's what we do, and we do them together. And the goal is, with the name High Impact Litigation, to focus on high impact cases. So we're going to talk about, just give a quick update on a couple of the ones that we are working on. So I don't have all of Chuck's fancy banners and all that because I'm logged in from my version of StreamYard this week. But let's get started with the I-601A case. I don't know, Aaron, if you want to start with that. There's been kind of a mix of news, some not so great news, some better news today. So why don't you give the update?
Sure. I'm actually going to call this update kind of about the I-601 case and the I-601A case, because on the specific cases, I don't think we have any updates as far as filings or decisions or anything like that. So nothing specific to either case there. But we do have news that's very hot off the presses in a good decision out of District of Colorado, where I reside. So there's a case called Granados v. United States, and it is actually, I think, a consolidated case with, I want to say, 25 different I-601A plaintiffs. In that case, the government filed a motion to dismiss, and the judge in the case just denied the motion to dismiss. This is one of the first good decisions we've had in a while. There'd been a little bit of a trickle of negative decisions where the courts had accepted the government's arguments that there wasn't jurisdiction over these cases, and this judge rejected their arguments. He said that basically the government doesn't have discretion to never decide these applications, and that there must be some kind of possible case for unreasonable delay. Now, they haven't won their case. The judge didn't say that the delay was unreasonable. He just said that he has discretion to make a decision. And he actually did express some doubts about whether the case would be viable, but he didn't get to the merits very much, because he said, you know what, we're going to set a status conference on that case, and we are going to decide to what extent discovery is necessary before they really get into the merits of the factors on whether a delay is unreasonable. So that little piece is actually very positive, because discovery from the agency is what we need to open these cases up and explain what is happening is not happening according to any kind of orderly process, and there's been some kind of major change in the last few years to cause these ballooning processing times. So it's very good news. We're actually already in contact with counsel on that case. His name's Sean Mead. He's out of Colorado. He's done a lot of good work. So we're excited that he's on that case. We're in contact. We'll probably be doing a bit of collaboration and the and giving any support that he wants on the request for discovery. And so we look forward to that.
Good. I guess probably last week we talked. Was there discussion of the other issue with regard to the having to wait on the Ninth Circuit?
We did. We
Okay.
did. Yeah, we talked about that. So they did stay the 601A case for the Ninth Circuit, but so they're still going to wait on a decision there. But this positive authority is still a good thing.
It's going to help. All right. Okay, good. And the related, it's not a related case, but it's sort of like it's similar. It's in a similar vein. The 601 waiver case. What is there any news to report on that?
No news other than that these are the same issues about whether a court has jurisdiction to make a decision on whether these delays are reasonable or unreasonable for what's a discretionary benefit. And so any decisions that are positive on the 601A case are also positive for the 601 case.
Okay. Okay. Let's switch subjects to Ukrainians. So, Jesse, there have been some some recent filings in that case. The Astakov case. It used to be called Shumalina the first round. Now it's Astakov, and this is the one that is a class action case to try and seek fee refunds and get some declarations of, from the government. So can you tell a little bit about what was filed in the last couple of days?
Sure. Yeah. So, and this is an important case, and we're seeking to have money returned for Ukrainian and Afghan nationals who were eligible for refugee benefits by law. And they today, the agency has understood that they do not take money from these individuals, but for a while they did. And we eventually we initially sued in Shumalina because they actually did not recognize that Ukrainian nationals who are entering under a program were supposed to be entitled to refugee benefits. And then they changed course and they stopped charging people, but then they didn't return the money they had taken from tens of thousands of individuals. And so we've, again, it's kind of similar to the 601A case in this, that this is a lot of lawyers getting, how do we get in the door to get the money back? Everyone, I think, can agree that the money was improperly taken. And so we filed in the District of Columbia. In fact, we actually filed a first suit, and then we joined forces and moved to the District of Columbia. And the government finally filed its response, and they filed a motion to dismiss saying, well, you really can't sue for this, and we're immune from having to give back money we theoretically, one would say, steal. You stole, and you really need to you should bring this case in another court, not this one, another one. And there's reasons for doing
it in a court where it's much more difficult to
actually
for the government to actually force the government to pay everybody back.
Right. So mathematically, they're saying we're going to pay a bunch of our lawyers rather than giving money back to the people who would probably need it, and actually we're not supposed to be paying in the first place. It's odd. It's a strange. It's an important case. It is extremely important that we don't allow our government to act like other governments where they just show up and take money from you, and what's next, right? They can just throw you in jail. Is that what Banana Republic stuff? That's really un-American. So I think this is just an incredibly important case just for the rule of law, and and it's insane to me that the government would fight and not give back the money. But here we are. So what do we have? We've told the court in the DC circuit, hey, you need to take a look at it, Judge. We've also moved for class certification because we want to make sure that we represent everybody who's had their money taken. And so we filed those two things this week with our partners, and I think the work is excellent. And we have a compelling case, and I'm really actually proud that we were able to do it. To be honest, it's a really fabulous case. So that's the update there. Again, it's lawyers just throwing paper at the court and waiting for judges to decide.
Yeah, and I'll just give a couple of just little policy or legislative and policy updates on Ukrainians, just because a lot of them are affected in this case. One, which was really good news for our plaintiffs, is that TPS was extended for Ukraine a couple of days ago for another 18 months. And it was, I believe, it was done in a way that now if you entered the country, and a lot of people didn't qualify for TPS because they came into the country too early or too late, rather, for TPS the last go around. And I believe they updated the dates for now. I mean, to like recently. So people that didn't qualify before that and were relying on parole can now qualify for TPS. And in some respects, TPS has, there are some benefits to being in TPS, especially when converting to a green card and employment authorization and things like that. But that's that being said, that was one piece of news. The other one is that there is new so the legislation that our case is about is Congress passed a bill that said anybody who entered in the parole program, Ukrainian parole program after February 22nd, 2022, and who entered the U.S. before September 30th, 2023, is to be treated as a refugee. There's been a question mark about whether that legislation was going to be extended. And the Biden administration has, and I don't know if it's actually been introduced yet, but they signaled that they want an extension of the Ukrainian supplemental language, and it should have an extension of the language that we rely on in there. It is a little bit tricky right now because there are Republicans who do not support Ukraine, and there's some questions about whether there's always threats of a government shutdown, and there's a question about whether they are going to try and force the administration to give up on its supplemental bill. I think that this is a major priority for Biden. It would be seen as a big loss for him, especially going into the campaign, but that there are some people who think that bill is going to struggle. So we'll have to see on that. I think that's it as far as Ukraine goes. I know that there are questions already in the out there about the Go and Gomez cases and the DV cases that are all tied up in the DC Circuit Court. We are coming up on the 1-year anniversary of the arguments in that case, and unfortunately, there's just very little that we can do other than tell you guys every week that this is weird that it's taking this long and that we've been expecting pretty much since the beginning of the calendar year a decision on that case. We don't know when it's coming. We absolutely have no ability to influence the court as far as when they make a decision on it. They can sit on it, as long as they want. Unfortunately, that's how courts work. But and there's no indication yet from the government that they are changing their position at all on it. So that's all I can think of to say about that. I don't know if you guys have anything else that you want to add.
I mean, I just, I argued a case in May that came down last week, so I don't think that you can use a benchmark to decide. I think the case is going to be split. Like we've said, we're going to have a judge who's going to disagree with the other two judges. And that's probably the reason it's taken so long. I think the case is going to have, obviously it's going to affect those who are part of the DV 2020 and 2021 programs, but it's going to have an enormous impact on these cases that we're talking about today, because there's going to be a lot of comments on executive power and when judges can interfere with it. And that's the battle we're having. I mean, honestly,
it'll be interesting. I mean, it kind of like the Biden administration is very similar to past administrations where they are very protective of their power. And sometimes, in this case, I think it's unfortunate that they seem like they're sort of blindly protective of their power, where it doesn't really matter whether it's an anti-immigration or a pro-immigration impact. If it means, if a court case means that their power is going to be curtailed in one way or the other, they're going to oppose. They could have fixed this, of course, by policy without letting it get this far. Obviously there are some instances like in the, we've just been talking about parole, the humanitarian parole program for Ukrainians. There's a really important program for South and Central America that is in the courts, and some of the same arguments are coming up there by anti-immigrant groups that are pushing it, particularly Republican governors. It'll be interesting. I mean, the administration seems to be having some success on executive authority and at the core level, and it kind of cuts both ways depending on what the policy issue is, which is why this is unfortunate that we're litigating here, because if we lose on that case, it wasn't necessary. They could have fixed this with policy changes rather than forcing it to go this far, but there's still no indication that that's what they're looking to do. I mean, we would happily settle if they would come up with something reasonable, but they haven't. That hasn't been in something that they've even explored.
No, I mean, there were people in the Gomez camp, I mean, who are just the really best and brightest attorneys, who were convinced that once we got summary judgment, they were going to settle. And why wouldn't you, just issue the visas to the people? Your president ran on that program of expanding the program to increasing the number. Like, why don't we just issue the ones that we had? But yeah, no, it's, and it's crazy because if you look at executive authority, we do have an administration that has actually went the other way, right? So we say, hey, you at least have to, you can issue visas, you can follow a court order. It was issued before the deadline. And they say, hey, the rules are the rules, and we can't violate the rules. And then last year, and again, I think this year, they're going to issue more diversity visas than are available. I mean, so it just goes to show you that the executive mindset is, I get to do whatever I want, and whether there's rules or not. And again, that's what we're talking about. A lot of what we have in this country right now can be taught in social studies in 7th grade. We have ineffective branch in Congress, and we have the courts and the president deciding who gets to have some checks and balances. It's unfortunate.
Yeah.
This touches on a theme that we often talk about, but and with the caveat that I've never worked at the Department of Justice, so I don't have any knowledge of the inner workings like Jesse does. But what's frustrating to me is that you have the government arguing in Patel that the position that the Supreme Court ultimately took was crazy, that it wasn't the right reading of the statute. The government's argument was more friendly to the immigrant in that case, as far as what kind of jurisdiction the courts have. Yeah. And then since Patel, and apart from Patel, also in the DB cases, the attorneys for the government have been taking a real maximalist approach to arguing how much jurisdiction has been stripped from the courts by some of these statutes. And it's the reason it's frustrating to me is because I get the sense that the culture at DOJ is just for their attorneys to take all the possible arguments and try to win cases. Mm-hmm. And to a large extent, it often goes against what I think the administration's espoused positions are. Like, would the administration have said no court should never have jurisdiction over a case like this if it got to high enough levels? I don't know. Maybe they don't care, but it seems there's some tension between the position they took in Patel, which was better, and the maximalist position they're taking now in all these cases. I don't understand it.
You have, so the mantra at DOJ is you do what the Attorney General tells you to do. Okay. So Garland could simply say, this is a litigation position of the president and the department. And then you have the Solicitor General as well. I remember back in the day, the Solicitor General was so terrified of consular non-reviewability and did not believe in it. And this is a time when Elena Kagan was up there. Okay. Mm-hmm. She was a Solicitor General. I'm not saying it was her, but you know where I'm going with this. And we didn't argue consular non-reviewability for a couple of years because we were terrified of losing. Kerry v. Din was not a good decision, and in some people's eyes, you know, and a lot of people didn't think, were afraid that it would go away. And so, yeah, it starts at the top. It always does. And if you're a 27-year-old kid at DOJ, you do what your job is to do. I mean, you know, again, you can run it up the chain, but a lot of times, the litigation positions, just like the prosecutorial discretion, right? They're memos issued by people who you have to follow to keep your job. There is not, this is not for you to go out there and invent. If you want to go invent something, go work at a different company. That's it.
And it just gets to me because there's ways that they could argue for their clients that are not saying courts don't have jurisdictions. They could put forth arguments saying, look, our agency's overwhelmed and we're doing the best we can.
I'm pretty sure their client wants them to be arguing the positions they're arguing because this is a position of convenience for them. They may have pro-immigration people that have been appointed to senior positions at the agency, but at the end of the day, they want all these cases to go away.
Well, and here's the other thing too, you have to understand, right? And this is coming from a place where I have really firsthand knowledge. Nobody at DOJ, and I'm not saying nobody, but most of the people have no idea like what an EB-5 is, right? 526, what are you talking about? 601A? They've never seen the form. They don't know what it is. They know jurisdiction though, and they know those statutes and those arguments. And so I guess it's more natural to them because they are trained in that type of litigation. They're not trained in a 589 form. They've seen 1,000 of them in records, but they have no idea how to fill one out. They don't know what an asylum interview entails. They've never been to one, So I think that, and they're incredibly insensitive to the real world implications because unless they've worked out and come back into the DOJ. And that's usually not how it starts. Usually you stay there, you start there, you're bred there. You're just insensitive. I was certainly insensitive to, what is out in the real world. I can tell you that first big case that I had when I showed up in Chicago and saw a kid in the freaking cage separated from his mother. I was shocked. I could not believe that actually would have happened. You read it and then you see it. And again, and then you had a DOJ attorney on the other side. I remember this very well say, well, judge said, how can this be? You need to show me a case where you are allowed to separate, children from their mothers. And she said, well, I got a flight. So I'm going to tell you and the judge was like, excuse me, but it tells you that DOJ, we're not in tune to people's lives. And I think that is actually a place where the department could really learn and understand that you're going to win on 601As and allow the agency to do nothing forever. And what are you going to end up achieving? You're going to achieve what? Mass unemployment, family separation, removal of separation of families. And you want a round of applause for that? Or what are we doing? We handing out awards now? Or, with the DV folks.
So do you think that Garland and the DOJ, that they are thinking about, these policy implications and, or is it pretty much we're serving our client and this is what our client wants, the DHS and the USCIS. It's not really helpful if it's the latter as far as exposing them to these issues because their position is going to be, it doesn't matter what we think, it matters what our client thinks.
It doesn't seem to me that Garland is interested in immigration. I think, and it may be that he is interested, but he can't get there because he has January 6th and Trump and some other major litigation that his department has to deal with. Because he has criminal division and civil division, and then to the extent immigration's on the radar, it's probably border policies and taking away the Republicans' attempts to control what the president is really interested in, which is the border, and Mayorkas is the border. If you're already here, we don't really care. That's the way I get and that's the way I've understood the Biden immigration policy. If you're here, I don't care. If you're trying to get here, I kind of care, and I don't really know how to deal with it. But I'm going to listen to people and come up with some apps, and we'll figure it out. But I mean, that's what I get, right? Because it's coming from Biden. If Biden said, Biden wanted to control what Garland is doing, it would be a phone call or a memo. It'd be easy. No one's going to care what Mayorkas thinks if Biden disagrees. It starts at the way top, and it goes all the way down. In my view, I don't know much about this, what the Solicitor General's approach is, but that's a powerful position in government about litigation. And I think that this is my best case scenario for everybody. I think, to me, if Gomez and Good Luck go a way that's really favorable for us, and they put in language about how blatant executive authority and the overreach and how that just cannot happen, and don't even try to bring constitutional non-reviewability into this, and what you've done to people who deserve more than what you gave them. I think that I'd be scared to take DOJ the other side, and is more emboldened as they become winning some of these lawsuits about, hey, you have no jurisdiction to determine, when we make a judgment when we don't do anything, right? That's their litigation. I make a judgment by not doing anything on your case. You got to be careful because the way it usually works with DOJ, it's kind of like, I don't know, when was the last great victory? Maybe it was the DACA case or Regents or something, where they get really confident, okay? And then a court absolutely rips their arguments to shreds, and you start a new paradigm. And they're on their heels, and they say, wait a minute, we just got crushed. And I think it's coming. I think it's coming from the Supreme Court at some point, because you have so many justices up there that are so sick of the administrative state that they're willing to probably stomach an immigration win, as much as they hate immigration, just to tell the executive branch, like, hey, you can't do this stuff to people. I'm sorry. You can't tell me that you're making a judgment by sitting on your hands. I don't get it. That doesn't work. And the jurisdictional arguments are really smart, and they make a lot of great arguments, but the Supreme Court justices that are up there now at some point are going to say, like, that, we get it. Yeah, you're being cute with the arguments. It's bullshit. Get out of here. I think it's coming. I really do. It could be Gomez.
I hope you're right. All right. Well, I think we hit the cases that we need to hit today. Were there any that you guys can think of that we should be talking about that we didn't get to? I think we did. Anyway, we will be back next Wednesday at 12 Eastern time. And I don't know if Chuck's gonna be back yet, but the three of us should at least be there. And Chuck, if you're watching, we hope you feel better soon, and we'll see everybody the next time. So thanks, everybody.
Thanks, bud. All right.